Very good evening, everyone, and we welcome you into our session 5 of our Language of IP Law English webinar series 2024. So it's me, Sophia, and Dan, who welcome you into this evening. And today we have a very interesting topic, a very exciting, if I may use this word, topic on infringement in IP law. Our session will last for 1 hour and 30 minutes. And we have Professor Dr. Don Sloan with us, Dan Sloan from California, who is going to give us this presentation, and he will be asking you some questions, and you will be able to participate in answering the questions. In order to join the presentation, you have been sent a link, and also you can see it in all our social media. So you can just type in your name, join in the presentation, and when there are some quizzes, you will be able to answer. Also, please, if you have any questions, you can send them to our Telegram chat that you also have been provided with. Our live session is right now both in Vkontakte and on YouTube, so you can watch us wherever you wish to. We love the new technologies, and we're extremely excited to be tonight with Dan. Dan, welcome, and I'm very glad to see you tonight.
Thank you, Sophia. Yeah, I'm very pleased to be here. It's still beautiful in California. It's cold and lots of rain, so we need the rain in California. This is a great session. We're on session 5 already, going by quickly. Another 2 weeks, we'll have session 6 on AI and some other areas there. Very interesting topic as well. So I'm excited about the topics that we're doing here tonight and next time. Infringement can get very deep in terms of infringement clauses and other things. We're not going to go as deep as I'd like to because we just don't have enough time because it's such a big topic. But I am going to include some other information for you that you can put on the websites to make it available for the observers, for our attendees. So I'm Dr. Dan Sloan, and the information I'm providing here, if you've been on with us before, you have a QR code, or you have to join. You'll see up here by the cursor it'll drop down a way to join us on slides. Okay, so we're just going to go right into this and begin, and then when we get to the questions, we'll go over that a little bit more. So what is IP infringement? Kind of an overview here of what we are going to discuss. So we're talking about patents, monitoring for unauthorized use of patented inventions by competitors, or ensuring any potential infringement is swiftly identified and addressed through legal channels. That's part of what we're going to talk about here. And trademarks. Regularly survey the marketplace for similar branding and could confuse consumers. This happens a lot, in various areas of the world. Maybe inadvertently somebody makes a mistake, or sometimes it's intentional. But we're protecting the brand integrity by taking immediate corrective measures against unauthorized usage. We have to do that in order to retain the value of our brand. And then number 3, we're implementing a system to detect unauthorized reproductions or distributions of copyrighted works, maintaining stringent licensing agreements to safeguard original content. And as you will see, infringement, and I spoke of infringement clauses, are an incredibly important part of the work that we do. So understanding patent infringement. Well, we first have to be able to understand what to do about it and how to go about it. So monitor. We have to monitor competitors for potential product similarities or unauthorized use. We have to assess, and will regularly assess, compliance with patent licenses and product development. So the patent office is somewhere where we're going to watch and observe to ensure that there's nothing being brought in that doesn't comply. We're going to consult with IP lawyers to evaluate potential infringement clauses. You may be an IP lawyer yourself, and you're going to continue to update your training on that particular part of it. Educate through training your employees on or the client's employees on patent rights and identification of infringement. Looks like this got off a little bit, but we're going to implement software to continuously monitor patent use in market trends. And there's a great deal happening in AI, which we're going to go into in 2 weeks from now, about how to implement software and using better systems in order to detect and monitor the marketplace. And then act. We have to take swift action against identified infringements to deter future violations. We want to set the tone. If you violate the or infringe upon our patent rights, we will take action. And how do we do that is what we're going to go into next. So, introduction to property law, protecting ideas. We utilize intellectual property rights to safeguard your inventions and creative works for unauthorized use. We monitor the market through by implementing robust systems to identify and address potential infringements of your intellectual property. We draft contracts, incorporate clear IP indemnity clauses. There we go, those clauses in contracts to protect against infringement claims by third parties. Okay, and this is another part of the third party that we're going to talk about too. And then educating our staff, provide training for employees on IP rights and the importance of protecting company assets. So here's our first set of questions. And you want to either join, it's also over here, if you see on the left, where you can join through ahaslides.com/py1m2 or through scanning the code. So I'll give people a few minutes here to kind of not minutes, but a few seconds to log on.
And then can I also ask you to move the cursor up so those who want to, and just keep it so they can, and just keep it over there, because for some people it might be easy if they just type in as we realized. So
thank you.
And okay. We are very grateful to those who are joining us, because we understand that December is a very hectic month. It's the end of the year. Everyone is trying to get to the deadlines, wrap up things, and everything at work before the holiday season kicks in. And we're very glad that we are finishing our project right before the season starts in United States, if I'm not mistaken.
Yep. Okay, so we have a few players. I'm going to go ahead and start. You'll see the questions come up. Not all 23, of course. And I'm going to have to try to move this. Got to move my cursor. There we go. Which of the following actions is not recommended practice for protecting your intellectual property from infringement? Okay, so we have draft contracts with clear IP indemnity clauses, implement monitoring systems for patent usage, ignore any unauthorized use, assuming it will resolve itself, provide employee training for our intellectual property rights, and regularly survey the marketplace for potential trade conflicts. Okay, so it looks like everyone got that one right, at least everyone that voted. That one was pretty clear, and it was that word "not" in there that I wanted to make sure there was clear understanding on what was happening here. Very good. Let's see who got it first. Looks like Mariana is up there. She got a 94 out of 100, so that was quick. Ready for the next one? I'm going to go ahead and put this up here again. If you haven't joined, you can join there. Question 2. Which of the following strategies is most effective for detecting potential patent infringements in your business? Wait for a legal claim before taking any action. Educate your competitors about your patents. Only check for infringements once a year. Assume all patents are followed until proven otherwise, or regularly monitor competitors for unauthorized product similarities.
And when I'm reading now the questions, I'm just trying to understand, is there is like one answer or several?
It could be, but it could be one, but it could be more than one as well. Yeah.
Okay.
Ready? Okay, most people got that right. Yeah, very good. Regularly monitor competitors for unauthorized product similarity. The others are incorrect. Some of them are, I think, are a little more obvious than others, but yeah, one answer. Okay, we have one more. Let's see who's out there in front. Mariana. Oh, nope, we had Dasha. Dasha got a 94 on that one, and Mariana a little bit behind Dasha, but good job. Okay, next. Which of the following actions should a company take to monitor for potential copyright infringement? Regularly survey the market for unauthorized distribution of original content. Hire only freelance artists without contracts to save costs. Avoid licensing agreements altogether to reduce complexity. Keep all creative works confidential without documentation. Or implement a system to detect unauthorized reproductions of copyrighted works. Let's see how you do on this one. Which of the following actions should a company take to monitor for potential copyright infringement? Could be one or it could be more. There you go. There are two of them on this one. Most people got that one right. Very good. We're getting the message across clearly, which is what I wanted to see who came in first. Looks like Dasha's still out ahead. Mariana, Lena, and Ivan are heading up the pack here. Dasha's rocking the longest streak, it says. Okay. So understanding copyright infringement. Any questions yet on your side?
No, not yet.
All right. Implement continuous monitoring for unauthorized use of copyrighted materials through automated online tools and regular audits. Respond quickly to infringement by using cease and desist letters and exploring legal remedies to protect rights effectively and minimize economic loss. Now, many times there are systems that are built into the platforms that you use. So, as part of your use for a platform that you might be your client or yourself might have a product that is being advertised for sale or use for a license, they will actually monitor it for you. And for some examples of that might be Netflix or Amazon, to where they will detect, or even if you have YouTube access, sounds like you do, they will detect if there is content that's being uploaded that violates or infringes upon a copyright or a patent. And you probably may have noticed this if you tried to upload something and it's been rejected. It says it's infringing upon a patent or copyright. So that happens a lot. And it's great because now you don't have to have that expense if you have it provided for you. That's not always the case, depending upon the kind of content as well.
And then we have one question. If we can go back to the previous slide, I had a question about what does it mean, cease and desist letters?
Okay, so that's a great question. We're going to go into that a little more as
Okay.
well. But cease and desist. Cease and desist means you need to stop and comply with the patent that has been effectively in use and granted to the owner of the property. So what you're doing is you're sending a letter, email or otherwise, to someone who has infringed upon your property rights to protect them, and that's what that cease and desist letter is. It's a document that states you are infringing upon my rights as the owner of this property, and you need to stop. Okay.
And as I understand, it will be
or legal remedies. It could say that.
Sorry, and I apologize for interrupting you. And can I ask a question? Will it be like in the subject line of an email or a letter, like cease and desist letter, or it's like a form, or it will be even called like this? I'm not a specialist in this one.
Okay,
Так.
your audio broke up a little bit.
A little bit, yes. Okay, we'll fix it in a second. So then let me ask this question then later. So Dan, can you please go on, and I will get with the questions later, okay?
The audio is breaking up. I can't.
Uh-huh.
I hope you can hear me.
Yes, we can hear you. Так.
So cease and desist, we'll get to that in a moment as well. Go back here. There we are. Okay. So understanding industrial design infringements. So there's different kinds of infringements. I'm going to make sure that I have this correct. Yeah. Let's see. Yeah. Okay. So in industrial design infringement, we check for similarities. And checking for similarities means we're going to perform regular checks for similar designs in the marketplace. And usually that includes the use of technology and monitoring. And as I said, there's ways of doing that that are becoming much, much easier and much more streamlined and efficient. We're going to conduct audits to ensure compliance with design registrations. So what that would entail is maybe going to our third-party providers and conducting an audit to ensure that they are in compliance as well. We're going to inform the parties, involved parties about suspected infringement promptly. So when we do see a violation we will send off a cease and desist letter, which is the next one here. That's how we do that. We're utilizing letters, and we utilize cease and desist letters for initial infringement response. So immediately we would have our legal counsel draft a cease and desist letter outlining the exact property that is being used without permission or without a license, and that they should stop. And the consequences or remedies for that might be listed as well, that they could be liable for the cost of the infringement, the loss of the property value. They could be sued in court, various things that could happen. And that's this seek damages, the next step. Consider, since we have sent a letter, should we seek damages for the violation? So we would consider monetary compensation for losses due to infringement. What kind of loss is there? So that's part of the analysis. Is it a minor infringement, or is it something where it's been put out to the worldwide audience and we can no longer claw it back? And what would be the cost? Work strategies. So work with IP experts to design robust protection strategies. And many times you will find that this is the case in larger platforms like YouTube, Amazon, Netflix, that have content that's available, any large platform, to where they will have it segmented by region, meaning their content is not provided through the same portal, for example, worldwide. There might be areas of Asia or North America, South America that are provided content that is blocked and firewalled. Collect evidence. So we collect evidence of infringement for legal proceedings. So each and every step we go through here, we're going to collect and document the evidence so that in the event we do have to go to a legal proceeding, that we'll have that available. And then understanding geographical indication infringement. And this is what I was discussing just a moment ago. We're going to, where we have geographical firewalling, so to speak, we're going to monitor usage, regularly track the market for misleading uses of geographical indications that could impact consumer decisions. So we don't want somebody to use something that's licensed for one area of the world or one region and is being distributed without proper licensing. So that geographical indication would be very important. Are you hearing me okay?
We hear you wonderfully. The only thing, I see you with a little bit like slow-mo, and we are just thinking right now with Roman, so is it you or is it us? But I can hear you very well. So So we can go on. So I think the only thing that the video is a little bit slow. So, but
Yeah.
so
You know what a chipmunk is?
no.
It's a small animal and it goes "Tut, tut, 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 tut." And
This is
that's how I hear your voice sometimes.
okay. So there is some technology hiccup. So, but it seems like we can go on. So,
I
like,
just want to make sure it's clear.
no, no,
Okay.
no. You are absolutely clear.
Okay. So monitoring the usage on the global or geographical infringement. We're going to implement protections. We're going to develop and enforce robust strategies, protect geographical indications from unauthorized use or misrepresentation. Many times that's done through detecting the IP address. So, but as you probably are aware, you can use a VPN many times in order to disguise the location of where you are. In China, I lived in China for many years, and doing work there like I am doing now. And the Netflix and other content in English that I wanted to see, I could use my VPN. But then Netflix employed technology that would detect the use of a VPN so that they would secure those licenses of that content, those videos, so that they could protect it from being used because that's 21% of the world's population that could see Netflix and rebroadcast Netflix on other platforms. And so they weren't doing a good job until the technology improved. So that's kind of an example of how technology has changed to detect misuse and unauthorized use of content. Then we will educate stakeholders, conduct training for producers and consumers about the value of recognition of geographical indications. And this is very important to do because many times people are unaware of the legal ramifications without proper training of misusing or abusing content in areas of the world that are not authorized. So, especially if it's a third party that's maybe providing content that is not authorized, we don't want that to be put out there. It can also be a problem at a cultural scale or political, and content on occasion, especially videos, are put into areas of the world like in Islamic countries or in China, to where the content is prohibited. It's not supposed to be broadcast there for political or religious or other reasons. So it's very important to know that geographical recognition and what kind of value it has, so you don't subject your client to undue liability. And in understanding trademark infringement, okay? So we're going to regularly review trademarks for authorized, unauthorized use or similar branding. And that can happen inadvertently or intentionally. I've seen many of these cases throughout the world in my travels and living abroad. We want to implement tools to track online unauthorized trademark use effectively. And Apple, Apple, and in China they have Opal, Opple.
Are you serious?
Yeah. So and there's Opal stores, and the products are look very similar. So it can be difficult, because here there appears to be the possibility of infringement. So you would want people to investigate that in order to know that there's been a infraction, there's been a infringement upon the property rights of your client or yourself, and then what can you do about it? What are the remedies that are available? The first thing we would do if we did detect that, we would send a cease and desist letter again, promptly to infringers to assert our rights. We want to let them know immediately upon our discovery that the rights have been infringed upon and that they are to stop using that content in any way without proper licensing. Okay. We want to educate our staff on trademark importance and reporting potential infringements so that they are made aware. It's not just okay just to ignore it. We do need to know more about it and how to identify that content. And then consult with IP attorneys for effective trademark protection strategies. And those are constantly improving. And as the law changes in various areas of the world, we need people to keep up with it. So it's something you have to continually review. Okay, we're up to our second set of questions here. And I'll put this up here where you can see it. To join, you could go to ahaslides.com, PY1M2. And if you're ready to go, I'll go ahead and hit the start button and we'll see who can beat Mariana. She's up there now. There we go. What is the first step you should take when suspecting a trademark infringement? Educate your staff on trademark laws for future reference, or implement automated tracking tools before reviewing trademarks. Send a cease and desist letter without prior investigation. Immediately file a lawsuit against the suspected infringer, or conduct a market audit to check for similar trademarks.
And while we're waiting, can I ask a question? And actually now, can you hear me better now? Because
Definitely. Yeah,
yeah,
it's much.
yes, and we can see also better. So there was some, as I said, hiccup in the system. So I do have a question, but I will ask after we deal with it.
Ready? There you go. It looks like most people did not get this one correctly, but the correct answer is to conduct a market audit to check for similar trademarks. Okay. So what is the first step you should take when suspecting a trademark infringement? Conduct a market audit to check for similar trademarks. Send a cease and desist letter without prior investigation means you haven't done any due diligence. You haven't checked anything beforehand, right? You haven't done any investigation. You want to verify. You want to absolutely be sure before you send a cease and desist letter that you don't have to retract that letter and pull it back because, oops, I was wrong. We made a mistake. So that's kind of the lesson there.
And we do have a question about the cease and desist letter from Anastasia, who I suspect is a teacher of English. So she's asking whether desist is a synonym to cease, and why are they used together? Is it tradition, or there is some, like, just a name?
The difference between the two and I'll put something out there later after the lesson to more clarify it. But cease means you need to stop. Okay, that's the clear term of that one. Desist means no more. You cannot continue to do it in the future. So stop what you're currently doing, and then in the future, don't do any more.
Thank you very much.
That's why they put both. So if you said just cease using it, later you might go back and find that they are doing it again, and they will say, well, we stopped, but then we started again. And that's not what we want. Yeah.
Okay, thank you very much.
Okay, let's see who's in front this time. Natalia. Wow. Looks like 86 on that one. She did well. Okay, next one. Which of the following actions should be prioritized to effectively manage and prevent trademark infringement? Which of the following actions should be prioritized to effectively manage and prevent trademark infringement? Consult IP attorneys for proactive strategies. Ignore similarities in branding until they increase sales. Educate staff on trademark significance. Wait for complaints to arise before taking action, or regularly review trademarks for unauthorized use. And whatever you did on that end improved the quality greatly.
Great. Thank you.
Okay, we have three that are the priorities. To consult with IP attorneys for proactive strategies. Proactive meaning we're doing them ahead of time so that we can put those policies in place. Educate the staff on trademark significance so that they are aware that these have incredible value and that we're protecting them, and how to do that. And then regularly review trademarks for unauthorized use. And it's our due diligence. We have to continually do that. And employing technology is one of the very best ways. Let's see who is on top. Mariana's come back a little bit. We've got Natalia on top still yet. Mariana got a 92 on that. That was great. Lena, 90, and TJ pulling up the pack. So cross-border infringements in jurisdiction. So we're going to implement a comprehensive monitoring system to identify potential IP infringements across jurisdictions by leveraging legal audits and online tracking tools to swiftly detect unauthorized use, enabling proactive legal responses and aligning with local enforcement mechanisms for effective protection of intellectual property rights. That's a very long sentence with a lot of information. So monitoring, identifying across jurisdictions, which can be challenging, and then leveraging those legal audits and online tools. So TRIPS agreement and its implications. I'm sure you're all familiar with this. And we have in the TRIPS agreement, which is about the most comprehensive, that word that we had in here, a comprehensive monitoring strategy. The TRIPS agreement is one of the most comprehensive to ensure compliance with international intellectual property protection standards. Okay, that those standards are great through the WTO, the World Trade Organization, which is where TRIPS comes from. They facilitate access. So through those agreements, we already have an agreement to access the markets to recognize IP rights enforcement. We utilize the frameworks to establish frameworks for resolving international IP disputes. So we've already got all the frameworks already built in by using TRIPS. We promote innovation by safeguarding IP rights across member states. And that's been a big problem with many less developed countries, LDCs, is we want to instill the value of intellectual property so that people will be incentivized. And we spoke about this, I think, in the very first session that we and that's one of the big issues about protecting intellectual property. Without protecting the intellectual property, people are less likely to be motivated, to be incentivized to go out and produce something. If you work for 10, 15, 20 years in your profession and become an expert, world-renowned expert, and you can't protect that knowledge, then you're not likely to put it out there for people to just take without paying for it. You obviously have incredible value, and we want to protect that. So LDCs, less developed countries, need to have that protection, and TRIPS and the WTO help provide that. We want to encourage consistency, which the TRIPS agreement does. Encourages consistency in IP laws among WTO member countries. And then also it supports, like I said, the LDCs, developing countries, in enhancing their IP law frameworks, because maybe they're unaware. And a lot of this is education. And that is also available through TRIPS. Strengthen trade through international trade, through robust IP protection mechanisms. When you have better trade, generally you have better relationships. So that is also a benefit. And then implement systems to monitor adherence to TRIPS obligations globally. And I'm all for agreements to where countries can enter and understand what the rules are, and then what the enforcement mechanisms are, so that we can help incentivize and encourage people to use the value in that they have on their intellectual property in order to create income and royalties and benefits. It's amazing. And in key laws and agreements governing IP. Of course, the TRIPS is what we just spoke of, to establish minimum IP protection standards for WTO member countries, like trade-related aspects of intellectual property rights. That's what TRIPS stands for and is among the most comprehensive, considered the most comprehensive. We spoke of these before in earlier sessions, but also included is the Paris Convention. Ensures industrial property protections across member states. Berne Convention to facilitate international copyright protection among participating nations. And then the Madrid system, which streamlined international trademark registration for businesses worldwide.
And then we do have a question from Alona. So, and I think it is related to the previous slide. What is LDC?
LDC, okay, that's just an acronym for less developed countries.
Okay.
If you see a little box below, it says support developing countries and enhancing their IP law frameworks. So I spent a year in Laos working with the Ministry of Foreign Affairs, and a part of it was through the Ministry of, Justice, the Ministry of Justice, thinking their titles. In the Ministry of Justice, that's some of the things they were looking at is how do we create an environment? It's a communist country, and the property rights were not as well spelled out as we'd like for them to be for individual rights. And then how can we help develop those property rights so that individuals felt that they could produce something and then have value and not lose that value. So LDCs need this support because they need to bring capital, inward foreign direct investment, or other capital into their country. And that's hard to do without the robust systems that we have. They're spelled out here.
Thank you very much.
So global challenges in IP infringement. And this is where people are like, wow, that's very difficult to do. And it is very difficult. So jurisdictional issues, varied IP laws across nations create uncertainties. And we're going to talk about these more in the next session that we have, section 6, about how AI and other things are creating even more challenges. But the jurisdictions, we have the EU and, of course, America and other parts of the Western world, and as well as Asia. Each of us has their own national laws, but then you also have agreements. So those varied IP laws across nations create uncertainties, and businesses must strategize compliance and seek local legal counsel to mitigate risks in international markets. And it may be that when you contact the local legal counsel, that they will say, "Oh, we are part of one of these other conventions or agreements," and that'll clarify what each party has already understood by just joining the WTO agreement or TRIPS. And in enforcement costs, there could be some very high costs. Expenses in litigating IP infringement cases abroad necessitate effective budgeting and possibly alternative dispute resolution, ADR, alternative dispute resolution, methods to manage risks and cost efficiently. And that's one thing I would highly recommend is having a clause to where you had an ADR clause for either mitigation or dispute resolution methods to where you're going to have to take it to another venue, hopefully to reduce the cost. So here's the next quiz. I'll put that up there. Arbitration and mediation are the ADR. Okay, ready? Go. What is a significant challenge that businesses face regarding international IP laws? And there could be more than one. Minimized enforcement costs at all jurisdiction, uniform enforcement of IP rights globally, no need for local legal counsel, universal acceptance of all IP laws, compliance with varied local IP laws. What is a significant challenge that businesses face regarding international IP laws? Could
I
be
think
one or
I think it's so difficult because you cannot, for example, enforce your rights in one country, and this country becomes the place from where some pirated maybe copies can just spread all over the world. So and you can just stop it. So like this fountain or something like this. So
yeah. And I've seen this in various countries that I have been and lived in to where content was brought into the country and immediately copied and put into the cloud. So it gets it once it's there, it's hard to withdraw it. And if it's there's large populations, it might be firewalled in some ways because it's not accessible. But if it's a large population, that could be a very big loss. So, yeah, so you hit it with the compliance with very local IP laws. So how do you comply with all of them? Very good. Let's see who's out in front now. Okay, Mariana.
Marianne is
Mar
back.
He's back. And it says Margot is rocking the longest streak. So Margot's picking up in the in there, but Mariana's brought it up, and Lena, Ivan, and Anastasia. We're seeing some different names, which is good. It means some people are moving up the ladder here. Next one. Which of the following statements about the TRIPS agreement is not true? It encourages consistency in IP laws across its member nations. It facilitates access to international markets through IP rights laws. It supports developing countries in enhancing their IP frameworks. It directly replaces national IP laws in each member country. It establishes minimum IP protection standards for WTO member countries. Which one is not true?
And can we also ask a question? So the term, professional term or word is infringement. Can we use the word violation, or it is less used? So that was a question from our viewers.
Yeah, infringement, I think it is more specific, but also it encompasses things that isn't just a violation. Violation was that the other term you were using?
Yes. I had a question with one of our viewers. So because like a lot of people would say violation of an agreement, violation of the law. Can we say violation, as I understand, of rights, of IP rights?
Yeah.
So
In some ways, an infringement would include violations, but more than that. It's more broadly used to include things that may not appear to be a violation, but it would include things that are on the border. That they're
the lines are blurred, or something like
the
this.
lines are
Yes.
blurred. So if you say it's infringed, maybe you've intentionally tried to disguise that you're using my content, and it infringes upon it, and it's not as easy to detect. It will be eventually become a violation if we can prove it. But it directly
Okay.
replaces national laws, IP laws in each member country. No, it does not do that. You still have your own national laws, but then you have the WTO TRIPS agreement as well.
Thank
And
you very much.
again, I will put that together, more information on the specificity to those and get it back to you. Looks like Mariana still ahead. Sue is rocking the longest streak with 4. Good job. Lena, Ivan, and Dimitri. We're seeing different names. Lots of points there too. I like it. Okay, one more here. This question is, what is the main purpose of the TRIPS agreement? Is it to dismantle existing international trademark laws, to promote free trade without any regard to IP laws, to facilitate tax agreements between nations, to harmonize environmental regulations across nations, or to establish IP protection standards for WTO member countries? What is the main, and there may be more than one, so you have to look.
Mhm.
Taxes is an interesting issue as well.
Yes. So, and we do have a question from Victor. I can ask it after we discuss the answers.
Okay. So we had the last one here to establish, and I've got to change that, like we talked about before, to establish minimum IP protection standards for WTO member countries. Okay. So we have minimum standards that they would go by, and then each nation would have their own. So it does establish that, a benchmark. Go ahead with the question.
Yes, there is a question from Victor, which is very interesting. I think it's more about AI, our next session, but nevertheless, is ChatGPT currently used in the USA in the preparation and conducting or conduct of IP licensing?
Is it currently used?
Yes, is ChatGPT currently or used in preparation and conduct of IP licensing?
Ah, boy, each one of them has their own AI, and this is in regards to AI. Each one of them has their own AI component. And as we speak, they're improving dramatically. So what is employed now, and that I know of with my use of ChatGPT, um, is some of that content restriction, and it's a machine learning platform, machine language, and it will continue to improve as it has violations come in. But yeah, it does detect if there is content that is prohibited for various reasons. It's prohibited because it's lewd and crude or like pornography. It'll detect music or other content. It will cite the sources of content. If it's a restricted content, obviously it won't use it. Now, is it perfect? No, not yet. And I don't know that it ever will be. But yeah, they are allowing that to be monitored.
Thank you very
So I,
much.
I use I use AI extensively, and when I teach in person, especially, um, I encourage people to use AI. Some professors, some people have a different feeling on that. My feeling is it's the very best tool to perform research, analysis, to learn. So I encourage the use of AI. GPT as being one of them.
Okay, thank you very much. Thank you.
Sue's still on there. She's got 4 or 5 now. Mariana is back. And we've got Ivan in there and Lena and Dimitri. We're moving on to tools for monitoring IP infringement. So the online tools, using software to track brand names, trademarks, copyright materials across. By the way, just to get back to that, that was Dimitri that gave that or had that question.
Victor, sir.
Victor. So I will have much more on how AI is used for detecting those type of infringements. So next session, please be here. So online monitoring utilize software to track brand names, trademarks, and copyright materials across infringement detect across the internet for proactive infringement detection. And with AI, since it is so incredibly powerful, just as we were just speaking about, it will detect in ways that we maybe hadn't been able to before. So it'll investigate, it'll research, and produce content or at least recognition through that monitoring system. Legal audits conduct regular reviews of IP rights compliance to identify gaps and ensure robust protection against potential infringements. And those IP legal audits are something that you're going to want to put into a contract if you are licensing your IP, so that those legal audits are performed on third parties. They're something that you could ask Amazon or, for example, or YouTube to produce a uh, um, a legal audit of that content. And I know that in their platforms, they have it much better spelled out than you probably would. And it's something you could look into when signing an agreement with one of those to get an idea. Identifying signs of infringement. So, how do we know when someone is infringing on our IP rights? Well, obviously, the first one might be a decline in sales. So, sudden drops in sales or market share could indicate infringement, and that could happen very quickly. Product similarity, discovery of similar products or branding may suggest potential infringement. So somebody new has come onto the marketplace. One of the platforms has a similar audio, video, or other content. We want to investigate it. Customer complaints, inquiries about product authenticity can signal possible infringement, and that's a big one. People will complain, like I was discussing earlier. Is it Apple or Opal? And they may complain. I thought I was buying Apple, and I didn't get the quality I thought. Online presence, monitoring online platforms for unauthorized use of your IP is crucial. And you'll want to make sure that you either have people in your staff or your client does, or that they have a system or service that will do it for them. Market surveillance, regular check for similar trademarks in the marketplace can help detect issues. And then competitor actions, watching your competitors. Is very reasonable to think that you would do this. For potential imitational products can reveal infringements. Social media monitoring, tracking social media for mentions of similar products can indicate infringement. And then trademark restrictions. Checking for new trademark applications similar to yours can highlight infringement and help you get that cease and desist letter out before it's too late. KPIs, okay, in we want to see what, and that stands for key performance indicators. I put that just below it. We identify key issues or key items that we want to look at for effective brand protection. So brand protection may be used in different ways depending upon the different types of products, but we're going to find out what's unique about ours. And this just gives an example of how we might set up a dashboard in order to better detect and then illustrate that in terms of, are we being infringed upon? Have we been successful in our strategy or not? If our strategy is working, hopefully our current performance is going to be, we're going to be detecting it, and then we're going to have success in preventing it from happening again. And you'll see there infringements detected 120 at the bottom, infringements removed. So each time we have success through whatever methods we used, discussed earlier, success rate is 75%. Lost revenues, we're going to want to track that so that we can see that we're being effective and realistic in how we're doing with our performance. And then contract clauses, again, that infringement of our property include clear indemnity provisions in contracts requiring suppliers to defend IP infringement claims. Okay, so understand what that really means is that we're identifying provisions in the contracts to our suppliers to ensure that they are safeguarding and protecting our property, stating the process for notification and specifying remedies to be taken if infringement is confirmed, such as obtaining necessary rights and altering infringed products.
And we do have a question. So it's a question that came through Vkontakte, actually, so from Daria. So can you please explain what does indemnity provision is? As I understand, very simple terms. And I understand why she asks this question, because very often in Russia, it can be translated in different ways. So it's, how would you explain what does indemnity?
Indemnity provision means that if there is a loss, that the loss will be suffered by the third party, by our suppliers, that they will protect us from the loss.
Mm-hmm. Because in Russia, we usually translate it. So I would say indemnity clause is a clause. It's an promise to compensate the losses in the event of some trigger. Well, if there's some trigger event, there can be general indemnity, like the other party will cover all of the losses if some third party approaches, or it can be like protection or promise to compensate losses if there is some trigger event like violation of some warranty only. So or an allegation of infringement of copyright. So that's why there is this question, I think.
And we spoke about this, you and I did,
Yeah.
as well as just at the beginning of the session. I have another presentation that is as long as this one, just on this particular issue of clauses, contract clauses for infringement, because there are so many different types of indemnity provisions that could be put in to protect for various types of liability. And that's what you want, is to make sure that you've clearly identified what those provisions are going to cover, and in what kind of coverage there will be, and then specify what the remedies will be in the event there is an infringement. So we'll go into those a little bit, but again, I'll put that other PowerPoint together so that you can put it out to the
Thank
audience.
you so much. Thank you.
Very good question. So indemnity provisions, this will help a little bit here too. So the types is a defense obligation. Supplier must defend the claims. So just a defense obligation, that who's going to defend, because the litigation, the cost of defending it could be very high. Importance protects the IP holder's rights. Implementation clearly outline the responsibilities. Example, including legal fees. Like I said, it could be very expensive to litigate. Considerations strengthens contractual terms. So it gives you the ability to say, we know where each party stands if something were to happen. Notice and process. Okay, that's another type of an indemnity. Specify notification process. How does that work? If there's an infringement and they know about it, does it trigger something to say you have to notify us that our property rights have been infringed upon? It ensures that timely action. So maybe a cease and desist letter can be sent, or whatever remedies necessary. Implementation details the steps of reporting. Examples would be written notice requirements that cease and desist. It builds accountability. It lets each party know what the responsibilities are and who is to be held accountable. Remedies is another type. So it outlines the remedy actions. So in your indemnity provisions, you will have the remedies clause outlining the remedy actions that are necessary. It clarifies consequences of infringement. It defines the failure and penalties. It gives the right to modify the product, for example, and then provides legal backing to say, here's in advance what we're going to do in the case there is an infringement. Here are the remedies that are there available. And another type would be the key contractual elements. So exclusions of liability. Okay. What are some of the components that we want to put in there? Are there exclusions from liability that would be okay? We don't know. Safeguards against unforeseen claims. Limitations defined clearly for the implementation. Examples are preserving supplier warranties. Okay, we want to ensure that if they do have warranties, that we are preserving those rights. And then considerations ensures comprehensive coverage. Key contractual elements. So there's quite a few steps, and I have examples in the other presentation. As I said, it's much more detailed just on this one particular issue. And there you go. It's even in Russian.
Thank you.
Yeah. Could leave that up for a couple seconds here. Okay. Are you ready for another test on that part of it? Okay, here we go. What is a key challenge that businesses face when navigating international IP laws? Immediate resolution without legal counsel, standardized patent approval timeliness globally, lower costs of IP litigation in all jurisdiction, uniform enforcement of IP laws everywhere, or inconsistent enforcement of IP laws across countries. What is a key challenge that businesses face when navigating international IP laws?
And we have got two questions, but I will ask them later. Mm-hmm.
We have inconsistent enforcement of IP laws across countries. And that is true. The enforcement is really key in ensuring that the property rights are kept valid and that we retain that value and encourage, as we talked about before, to encourage production of more IP. So, what do we have for our question?
The question is very interesting. Dmitry asks, so Western media products are popular in some countries, but people often watch films or listen to music through piracy platforms, like, for example, in Russia, because we're under sanctions, or in China. So, and current sanctions block access to many licensed IP products. And then a very interesting question. Can an ordinary consumer be punished for it while visiting another country? That is interesting because while visiting another country, you basically do not violate the law.
That happens a great deal, unfortunately. And in America, you can be held accountable. You can be penalized. For example, if I were to come into the United States and in my suitcase, I had many different videos that were pirated and produced in China when I lived there. If I'm importing pirated content, then I could be responsible for that. Especially if the intent were for sale. So yeah, they would. It depends on the severity of the infringement and the purpose of the infringement. If I'm bringing, let's say I'm bringing in knockoff, what they call knockoff, right? The duplicate products or something. Physical products, not IP, but it is IP in a sense because it is designed, but it watches where they're very, very valuable and expensive, then you can end up with pirated content. As an individual, we're not so much as concerned on occasion, although you could be held liable. Depends upon the jurisdiction that you're going into. Very good question, though. Yeah.
And
If
the
you're
second
living,
question, yeah. And the second question for Dmitry, which is like a follow-up question, can such risks be avoided or mitigated for an ordinary consumer?
I think if you were unaware that the products that you were purchasing were not legally available to you as a end user, there's probably some mitigating factors in that. Obviously, if you were aware and you purposefully violated that, what would be considered a copyright or a patent infringement, that would be something that you'd be held accountable for. So it just depends upon the jurisdiction again as to whether that's a valid argument or not. I would definitely not want to be in the situation to where you intentionally violated and are bringing content or pirated um, content into another jurisdiction, especially when it had severe regulations against it.
Okay, thank you very much. Thank you.
It looks like Mariana still on top. Sue's still coming up from behind, though. Ivan, Lena, and Dimitri. Here we go. Which of the following actions can help companies detect potential IP infringement? Avoid tracking social media mentions of the brand, reduce advertising to cut costs, conduct market surveillance for similar trademarks, ignore customer complaints about product authenticity, or regularly monitor online platforms for unauthorized uses of IP. And that first one there about social media, I was doing some work with Harvard over the summer, and we were using something called a scraper. And that scraper will go into social networks and it will read all of the comments and it will detect different aspects of what you want it to search for. So it's being used with AI regularly. Okay,
That
so we
is
had two answers: conduct market surveillance for similar trademarks and regularly monitor online platforms for unauthorized uses of IP. Very good. Who is our leader now? Ariana's still up there. Ivan's catching up. Sue is still on the streak. Very good. Another one here. We've got about 23 minutes left. Is that right?
yes, absolutely correct.
What could be a significant indicator of potential IP infringement for a business? Observing higher legal fees for trademark registration, the launch of a new product with similar branding, a rise in social media engagement around your brand, a sudden drop in sales or market share, a sudden increase in customer complaints about product authenticity. What would be a significant indicator? There could be more than one.
Dear Dan, I'm afraid to say this, but I think again we have this issue with the last answer being always, not always, but sometimes. Oh
Very
no, good.
good.
I was starting getting worried, like, oh,
Oh no. I don't want to put them all as the last one. I understand. What could be a significant indicator of potential IP infringement for a business to launch a new product with similar branding or and a sudden drop in sales or market share? Okay. See who did. The guys did well on that. It looks like Mariana and Anastasia moved up. Ivan up there and Daria. I haven't seen that name in there yet. So that's great.
and we might have probably have Daria commented on you answering the question from Dmitry last time about the ordinary consumer who may be punished. So, and she says that I guess that commercial, not commercial purpose of such usage will be the factor of the severity of such infringement for an ordinary person who goes into another country.
It could be, and generally that would have a definite impact if you are importing into a jurisdiction that where there's a clear delineation, clear outlaw of pirated content, and most of them there are. Whether the enforcement, okay, and that's the key issue. Enforcement is there to restrict it from happening. That's important. But in the United States, if it's shown that you're bringing content into America that you know is pirated or not authentic or unlicensed, then you're going to be held to a higher standard because your intention is to sell that content and reap the rewards of somebody else's property. Yeah, definitely true. Okay, so economic impact is getting into that value, monetary value. Lost revenue. Billions are lost annually in IP intensive industries due to infringement. And that you can see that like you were discussing earlier, whether it's audio that you're downloading on a pirate platform or videos, movies. There's rebroadcasting that happens in some countries to where the purchase of one subscription is made and then it's rebroadcast to many people. That is also an infringement. Market share loss. Infringements lead to significant market share loss for legitimate companies. And then if it's a subscription type of platform, like I said, you could lose a lot of your customers because they're being pirated. Discourage investments. Frequent infringements discourage investment in research and development. And then job loss. High infringement rates correlate with job cuts in affected industries. And that is a shame to have people lose their jobs because others are stealing or effectively pirating their content. Market uncertainty. Infringements create uncertain market conditions for consumers and companies. It's very difficult if you are the producer of content to evaluate the economic value of future income if because you can't predict if you just lose your rights because they've been infringed upon, you lose all of those proceeds. That's very difficult. R&D costs, increased legal costs, strained budgets for research and develop and innovation efforts, and then compliant or complicate relationships. IP disputes can complicate trade relationships with other countries. And again, that is a big issue, bigger than most people realize, is that relationship you want to maintain because better relations and better economic activity lead to a more smoother type of environment. Policy and diplomatic issues, which is this part here. Trade negotiations. So we want to integrate IP protection in international agreements to enhance compliance and cooperation among member countries. Developing countries, got back to that, ensure equitable access to essential goods and technology while respecting IP rights of creators and innovators. And in many countries, I hear that where people are disappointed because they feel that they're having to pay too much for content that's coming outside of their region. So they feel that, gosh, I'm having to pay too much. I have to use the pirated version because I can't afford it. And that those are difficult issues, and that's what we want to address. Harmonization efforts promote standardization of IP laws across jurisdictions to simplify enforcement and reduce legal complexities. Emerging challenges in IP law. What are some of the things that we're having to do? Well, AI, we're going to get into that next time, which will be fantastic. Develop strategies to address authorship and ownership of AI generated works in IP frameworks. And that is a big, big issue that we're going to really look into a lot coming up, is how do we address that? Because if it's content that's been manipulated, a creative work by a computer, who owns it? Or who has the responsibility if harm comes from that content? Could be misleading. AI is known for doing what we call hallucinations. And hallucinations means it just makes things up. In America, we have examples of that in law to where cases have been created through AI that don't exist, and then attorneys will use them in arguments. And so it can be a big problem for them when they go to court and the case they argue doesn't exist.
So you have to double check and not rely on ChatGPT. Yes.
So what happens in that case? So yeah, and then who's responsible for the mistakes? And then biotechnology concerns. Implement policies protecting genetic resources and traditional knowledge while promoting fair use. Okay. Data protection. Balance IP rights with data privacy regulations and cross-border data flow requirements to protect the data. That biotechnology is also a big issue when you're implementing policies to protect genetic resources, because anymore in America, AMD or ADM, one of Archer Daniels Midland's ADM, produces a lot of seeds genetically altered, and it will produce the crop yield. What we call crop yield is the amount of produce or product that comes off of each acre of land can be as much as 5 to 10 times what it would be if it were not modified. So those are very, very valuable rights that they want to protect. Initial response steps to infringement. What do we do? Okay, we gather, document, examine, draft, decide, calculate, identify, and ensure. All those 8 steps. We're going to gather evidence on the suspected violations present. We're going to document the specific instances and examples of infringements. We're going to examine all the contracts and agreements related to IP. We're going to draft and send a cease and desist notification. So we're all along the steps here. You can see we're gathering and documenting and ensuring that we have accurate information and that we're investigating, doing our due diligence. We will decide if interim or perpetual injunctions are necessary. And interim means a step in between, or perpetual meaning that they continue over a longer duration. We're going to calculate potential losses resulting from the infringement so that we know what kind of injury or what kind of remedy is going to be necessary. Identify suitable remedies based upon the situation, and then ensure adherence to agreements post infringement actions. So we don't just leave the situation and say we're never going to revisit it. We have to continually come back and maybe do more work when we find an infringement occurs, and we're going to go back to step one with our person or entity that is infringed to ensure it doesn't repeat. Legal actions and remedies available. So issue a formal notice demanding cessation of infringing activities. That's the cease and desist. We're going to obtain injunctions, so injunctive relief. We're going to obtain temporary or permanent orders prohibiting further infringement. That's another step we can take. And then seek compensation, obviously, for the losses incurred due to the infringement. We're going to have request orders, request the court orders for destruction of the infringing products. So not only do we want them to cease and desist, but we're also going to ask a court to order the destruction of the infringing products. We're going to utilize customs and seize infringing goods at national borders. That's what I was discussing a little bit earlier, is to ensure that you have good customs and border control to prevent those products from coming across. Consider mediation or ADR, arbitration mediation, to resolve cross-border disputes. It's a much more effective way for many reasons, cost-wise, time-wise, and then to try to retain the relationship, because maybe the relationship is just injured and it's not broken. We can mend that relationship and keep our customers and keep the relationship. And we're going to conduct investigations through to gather evidence of infringement.
Mm-hmm. And our dear Dan, we have a question. We have a question, as I understand, about the step 2. So the question came through Vkontakte. So the question is about obtaining an injunction. No. The next slide. I mean, the step 2 in here, obtain an injunction. So I understand why this question is asked. So I have a question about obtaining an injunction. Do you need first to file a claim against someone in court, and as part of this process you get an injunction, or it is a separate procedure apart from filing a claim?
I think it would be either with, it depends on the severity. So if it's you're going to file a claim and then the person continues to do so, then you would say, we need an injunction to prevent that from happening. If the claim were very serious, obviously you would include both. Have the claim and an injunction attached to it. So that injunction is basically the court saying, until you come and argue that you have the right to infringe or that you have not infringed, it's a misunderstanding or something else, until it comes to court, that would be a temporary injunction. A permanent injunction might be because the severity is so high that it's obvious an infringement has occurred and the person's just willfully using your property to create income or whatever purposes are used.
Yeah, as I understand, the question was here mostly that can you obtain an injunction out of any court procedure? Without filing a claim. So is it a separate procedure? So can you just present your patent, obviously, or something, and get an injunction against someone?
You probably could, depends upon the jurisdiction, but most of the time you have a claim to the right and a claim that it's been infringed upon. So that claim would be important to have. And then the injunction, you may have a claim to it, and the severity is not very high, but you're trying to prevent somebody from abusing your rights.
Hmm.
But the injunction is there because it's saying the severity is so high that we want to stop the activity and to prevent it from happening until a court can review the issue, the claim,
Hmm.
and then make that judgment. And if the court finds that no, the infringement did not occur, that there's a misunderstanding or it's being used properly, the court can go ahead
Lift the
and
injunction.
right,
Yes.
with the
Hmm.
injunction. Or it could be a permanent injunction to where the severity is so high that it's obvious that it's occurring.
Okay, thank you very much. I understand why this question is being asked because we have a little bit different procedure. So, and well, not different, but everyone is interested in the procedure abroad, how it works. So that's
You
why.
would definitely want to file the first issue there, issue a
Hmm.
formal notice of demanding cessation of infringing activities, and then file a claim if you've been harmed by
Hmm.
the use of your content. In the event that it is severe enough, you would want to prevent it through an injunction.
Hmm.
It could be done together or separately.
And there are two also questions which also came through Vkontakte. So one of them is very about a very small thing. What is the difference between profit and revenue? As I understand, the question goes back to a couple of previous slides when you spoke about loss of revenue. And the person is asking, like, can you say loss of profit? Or it's more traditional to say loss of revenue. What can be the
Those
consequences of?
those are two very different things.
Uh-huh.
Revenue and profit are two very different things. So revenue means how much income came in, right? Total income. So if you sell $1 million, for example, and but you did not take out your expenses,
Mm-hmm.
right? So you have income and expense on a accounting form. The difference between the income and expense is profit, right?
Mm-hmm.
So total revenue would be all of the income that you have from your operations. So that you would want to know because maybe you are in a startup and your startup is not yet making a profit.
Mm-hmm.
It's not it hasn't reached what we call economies of scale. So it's not big enough yet to make a profit. But your revenues keep increasing, showing that your business is doing better each period. So in 3 months, you double. Your revenue is double, but you still do not have a profit.
So like the money before the deductions. So all the
Yeah.
money coming into.
So they're
Mm-hmm.
completely different things. So what
Mm-hmm.
happens is like we have an electric car company called Rivian in America that's doing extremely well, but their cars are losing 100 and like $10,000 per vehicle for every vehicle they sell. So they're still losing a tremendous amount of money, but they increase the number of cars. And as they increase, their cost per car will go down until they reach a point to where they'll start making a profit. And that same thing happens with all of this, the IP and other things. If you only sell one of your products, an IP product, you're probably not going to make a profit because you spent so much in the creation of it. But if you sell a million, then you're going to be making a profit, for
Mm-hmm.
example, right?
Thank you very much. That was a question from Konstantin, and he has a second question. So, as I understand, it is related to an indemnity clause. How would you comment on the expression hold harmless? So, like for example, in a sentence or in a clause, you can see that party A shall indemnify party B against and hold harmless against all of the losses and so on. How would you explain, or how you can help to explain, what does hold harmless mean? So it's a very
It's
specific question.
yeah. It the basic meaning would be that the party would want to be protected so that they were not going to suffer the consequences of a loss, whatever that might be. They're holding
Hmm.
harmless. So if you sign this, if you are the signator to it, saying that you are going to hold another party harmless, then you are going to absorb all of the cost, whether it's financial cost, whether it's remediation, destruction, litigation, whatever the issues are. You are going to absorb that cost,
Mm-hmm.
prevent harm to another party. And if you are the party that is requiring that in your contract, then you are going to say that in the event, and these are very specific issues, like you said, it would be for something precise according to those clauses that we were discussing earlier. For each clause, you would say that if there is a violation of that clause, that if you violate it, then you will make sure that I am protected completely, holding harmless, holding me so that I am not injured in any way.
Mm-hmm. Okay, thank you very much. Thank you. Thanks a lot.
Speaking, is there another one, or is that
Well,
right?
there is actually not a question, but a comment. There is a comment on Daria that we discussed ChatGPT helping lawyers and sometimes making mistakes. That Daria says, I came across the legal requirements in some states of the USA that the attorney should state at the bottom of their claim or lawsuit that the document was not prepared with the help of AI. I think it's a very nice thing.
I think that is probably where we are going, but at the same time, I don't know that you can even say that because so much content before it comes to you is being altered or manipulated by AI. You see what I'm saying? So
Mm-hmm.
how can you make that statement when the content is put into the legal realm using AI? Because in the legal realm, in legal quarters everywhere, AI is one of the most prolific, users of law. So I mean, it's being generated at phenomenal speeds. So
Mm-hmm.
if you are in the legal field, you are going to be using AI.
So the documents that you are getting might have been altered by AI. Maybe it's not you, but you already got something, and anyway, you are using it. Sort of, yeah.
In research, and I'm talking very legitimate ways, nothing that's nefarious or illicit, illegal. It would be good reasons that lawyers would use AI, very good reasons. The research, the strategies, just that alone is phenomenal. So I don't know how you could say that it would not be generated by AI. That would be hard to defend if you make that statement.
Okay, thank you very much. So, and I'm afraid we have 1 minute left, Dan.
1 minute. Okay. Seeking compensation, request orders, utilize customs, consider ADR, and conduct investigations. I'm going to go ahead and put this out there for you through you, Sophia, and
Mm-hmm.
then the other one as well, so that they're available to our attendees here today.
Mm-hmm. And we need to wrap up. And I think with our the last several minutes discussion, we set the floor for our very exciting next topic, which will be about AI. So,
And it will be fantastic. You definitely want to come to this next one because it'll be very motivating for the future.
thank you so much. So, and the final comments is that our next session will be our final session number 6. And as we already said several times, please come because it will be about very interesting view on AI. And we're eager to listen to Dan about what he thinks about it, plus being such an eager user of AI and plus working in the field of law. And what is also important for us, we are coming to the end of our project, of our series. It means that on the 18th of December, we are going to have our final session, and then there will be several days for you to wrap up, to look at the all of the videos and presentations. And then on the 21st and 22nd of December, we're going to have an online test for those who would like to get a certificate. So a free certificate that you have gone through the series, and the certificate that sort of certifies that you are familiar with the vocabulary with it. So please stay in touch. We'll send you the link. It will be on the 21st in the morning. You will get 2 days to do it. So you will have time. You can rewatch the videos. You can go through the presentations, and all of the questions there will be based upon the presentations in our videos. So just wanted to say this. And the last but not least, so Dan, thank you very much for today. The time flew by, and we're very, very grateful to you.
Yeah, thank you. This is fantastic information, and I'm just very pleased that we could work together on this. Thank you.
I'm also very happy, and bye-bye, everyone. See you in 2 weeks. See you, and bye, Dan. Bye.